So we will move on now to our next presenter. This next guy is one who is very familiar to some of us. Paul Dubbeling, I refer to as Narsaal's White Knight. We keep sending him into these court battles, and he's doing very well at it. And we're very appreciative of all that Paul does for us. Paul is a former Army Ranger and infantry officer. He attended law school on an Army scholarship and graduated summa cum laude from Indiana University in 2005. He had served as a JAG attorney for 6 years, including 2 tours of Afghanistan. And after leaving the Army, he actually clerked for Judge Neil Gorsuch, who is now our Supreme Court Justice, and then ultimately went into private practice. He has also earned an MBA degree from Duke University. On the legal front, he had successfully prosecuted Doe's versus Cooper, a federal lawsuit which struck down most of North Carolina's previous premises restrictions, and is currently lead counsel for Narsaal's legal challenge to the North Carolina registration laws, Narsaal v. Stein. More recently, Paul won an important procedural due process victory in Meredith v. Stein, which was followed by, if I say this right, Grabarsig v. Stein. Paul, if I get the name slaughtered, you can correct that. It's a class action suit seeking relief for everyone who registered in North Carolina before 2006 for an out-of-state conviction. Paul's presentation is called Heroism and Faith, Becoming a Leader in the Fight for Change. He advocates that lasting legal change is a combination of litigation and legislation, but asks what we need to do those successfully. In this presentation, Paul will discuss what it takes to individually become leaders of change. Paul, welcome again. As always, it's a delight to see you again and have you here presenting for us this afternoon. The floor is yours.
Thank you. It's a little odd, frankly, speaking to everyone over Zoom, and I'm sorry that we can't be together. I look forward to the Narsaal conference annually, and I look forward to speaking with people live and in person and going over what's been going on in the past year, what we have coming up, and how we can move forward. But as I was thinking about this talk that I was going to give today, it occurred to me that it might be a good time to take a step back and look at what's going on in the world, look at what we're doing as a group, what we're advocating for, and reaffirm for ourselves some of the first principles that we believe in, and talk about how to take those first principles and move them forward into lasting change. I've been really impressed as I've been listening to some of the other presenters today who have touched on some of the same things I'm going to talk about. And I think the reason for that is that these are current issues that bear talking about. They're current issues that we need to focus on, and they're current issues that we can, frankly, by considering, see a relatively clear path forward. As I was looking around, thinking about what to talk about and thinking about these issues, it occurred to me that I think if we go back to first principles in a way, if we think about who we are, what we're doing, why we're doing it, what we're appealing to when we say that there's a need for reform, the path forward actually becomes a lot clearer than maybe it seems at times. We can get lost in this idea that we're fighting for this, or, it's a litigation battle and this. We can get caught up in whatever's going on in the moment. And by taking a step back, I think we can see how the moment fits into a bigger picture of what we're doing. And so that's what I want to talk about. The things I'm going to say aren't, frankly, particularly new. They're things that other presenters have said today. They're things that I've said in the past. But they're things that are fundamentally important. And I think by going over them, we can, again, take a step back, realize who we are, what we're fighting for, and talk about a coherent picture about how to get there. So I want you to bear with me for a second as I want to talk about that fundamental question, who we are. What are we doing here? And by your presence in this conference, by your presence listening to me talk right now, I already know that you are people who want to be leaders in some sense. You want to see change. And beyond that, I want to reiterate what some other speakers have said. And I want to take a step back, and I want to ask you to bear with me for a moment to think about language, and think about how language is used, and think about what it means, and think about how those truths impact what we're trying to do. It was spoken about earlier, but when we use a label for someone, when we say that a woman is a B word, or we say that a person of color is an N word or whatever, the purpose of that speech, the purpose behind what people are doing there is to dehumanize the other person. And if you look on NARSOL's website, it says that its primary purpose, the primary purpose of what we're trying to do is force the recognition of humanity. Force the recognition that people who have been convicted of sex offenses do not therefore become non-human. That is not licensed philosophically, morally, factually, to then deny to them the basic respect and dignity that is due to human beings, to individuals. When someone seeks to deny you your individuality, or frankly, when we do it, when we try to deny someone their individuality, when we try to dehumanize them, we are making them an other. We are making them someone not deserving of respect. We're then giving ourselves permission to do things to them that we would recognize you can't do to human beings, that we would recognize are antithetical to the values of Western liberal democracy. And I posit for you that those two things are intertwined, that what we mean when we say it's dehumanizing is we mean that we're refusing to recognize and respect the individuality of the individual. When you call someone a pejorative, what you're doing is you're lumping them into a class. You're saying you're not an individual. The overriding characteristic, the thing that is most definitive about you, is whatever you mean by this label. And it's that rhetorical move that is at the heart of most movements, most isms, if you will. And it's fundamentally the thing that needs to be fought back against. Now, taking one step further, I want to reiterate that this same rhetorical move is exactly what goes on when you label someone a criminal. When we call someone a criminal, when we accept there's such a thing as criminals and non-criminals, what we're really doing is saying that human beings are not defined by who they are. They're fully and totally defined by what they've done. We're saying that this one act is not a thing that you've done, but what you are. And that's the problem, because it carries the same follow-through, right? What we're saying is, because you are a criminal, therefore this, and this follows, and that's okay in some meaningful sense. And turning to the big one, of course, this is exactly what's going on when we use the term sex offender, when we accept the label sex offenders, when we agree that there is such a thing as a sex offender, as opposed to someone who has committed an offense, a sexual offense. We are saying that because someone did this, they therefore are this. And what I want to say clearly here, as has been said before, that's wrong. To take what someone's done and posit that that is what they are is wrong factually, it's wrong philosophically, and it's wrong morally. It's wrong factually because think about this. We wouldn't accept in our lives the idea that a single act that we've committed defines who we are. We wouldn't accept that. You look at the head of the New York Policemen's Benevolent Association, who is railing against the idea that you can take the acts of an individual or you can take a single act and define a group of people that way, right? We have this instinctive belief that this is factually wrong. We have this instinctive belief that it's morally wrong. And we have this sort of Western philosophical belief that this is not what it means to be human, that humanity, our lives are defined by the sum total of what we do, not by a single act. And the entire premise of sex offender registry laws is exactly contrary to this. It is entirely premised on the idea that there is a single act that defines who you are and that therefore gives society permission to do whatever it wants because you no longer deserve recognition of the individual circumstances of your life, much less your offense, much less whether these restrictions will do any of the things that are supposed to be good in terms of public policy. And that's what I want to posit that we're fundamentally fighting for. I want to turn the page from what are we fighting against to what are we fighting for, and I want to suggest that what we are fighting for is the idea that human beings, humanity, is an individual prospect, that it is fundamentally wrong to take something that someone has done and use that to define who they are, that proper public policy, moral public policy, factual reality requires us to look at the individual, requires us to recognize individuality and recognize that it is antithetical to the moral values of Western society to lump people into categories, to make lists, and based upon those lists, define what aspects of free society they're entitled to participate in without regard to their individuality. So against that backdrop, I want to ask the question who we are, and I want to posit that we are not sex offenders. We are not the family members of sex offenders. We are not people fighting specifically for sex offender reform. I want to reject that rhetoric, and I want to reject it because it gives away too much. It allows and causes us to fall into exactly the same fundamental type of thinking that creates the fundamental wrongness of how these laws are structured. And I want to say that who we are is people fighting for the fundamental right to be considered and treated as individuals. And that's it, in a sense. I want to say that if we strip away everything, yes, we're fighting for repeal of registry laws. Yes, we're fighting for various specific social inactives. But if you peel it away, what makes what we're doing the same as other movements, what makes what we're doing sort of fundamental, the appeal that we're making, is that sex offender registry laws are wrong because they refuse to recognize the individual. And almost any time you do that, you're going to go wrong. And you're going to go wrong because that refusal to recognize individuality is factually, morally, and philosophically wrong. We believe that. When I was in the Army, one of my jobs was teaching the people that ultimately did interrogations and, frankly, guarding prisoners of war, teaching them what the laws of war are, what is and is not torture. And none of this is classified. It's in the Army manual. But at that time, the Army defined torture as things that you wouldn't want to have done to an American. That was it. And the challenge was, well, how do you teach that? And what I learned was that the way you teach that is you just answer questions. So I would go into a room and I would talk to guys and they would say, well, this doesn't make sense. How do we know what that is? And I would say, okay, well, let's take the example of keeping someone awake, right? If you knew that an American soldier was forced to be kept awake for 24 straight hours, would you think that was torture? And almost universally, people said no. And so the next question would be, okay, what if you keep someone awake for 48 hours? And at 48 hours, people would start to get uneasy. People would start to say, that's not fantastic. But I'd say, okay, but is it torture? And 95% of people would say no. Sometimes someone would say yes, but rarely. If you change the answer to 72 hours, everyone would say it was torture. And what I took from that was that despite all the differences, despite these sort of political divides, cultural divides, what have you, it is true that people tend to share a fundamental perception of the rights that you owe people. If you can cut through groupthink, if you can turn the question from what is torture in the abstract, or how do we treat the enemy, and ask ourselves, is this torture? And ask people to consider that question in the context of considering whether they would consider it torture if done to them. If you ask them to consider themselves and their individuality and what it means to be human, there's remarkable agreement on the answers. Remarkable agreement. And so what I'm proposing here is that at bedrock, and this is an element of the faith that I wanted to talk about, at bedrock, Americans, by and large, believe in the sanctity of the individual. Now, that sanctity gets expressed in a million different ways. There's a lot of argument about who counts as an individual. There's a lot of argument about how this plays out, how this manifests. But if you take a step back, there is within American society a near universal belief that the individual is important and that the individual deserves respect. And so I posit that, one, that's the element of faith that we need. One, most people in the United States do not believe in their heart in denying individuality to others. Now, there's laziness, there's greed, there's cynicism, there's all sorts of reasons why people would ignore that truth. And sometimes it's just that people don't see the question in terms of that truth. But what I'm positing, the faith that I bring to this conversation, the faith that I bring to almost all of the work that I do, is at root, very few people are willing to look you in the eye, and very few people can look you in the eye and say, honestly, you're not human, that you're not an individual. Very few people can really sustain and defend the idea that they're thinking in terms of groups. Most people don't believe that a single act defines your life. Most people believe in the power of redemption, in the power of contrition. Most people believe that the sum of a human life is the sum of the individual circumstances of that life. And with that element of faith, I do think that there are ways forward. There are ways to move this conversation forward, but it starts with rejecting the idea that the world can be divided into us and them, that the world can be divided into these groups coherently. Now, sometimes we have to do that. Language is structured that way. Sometimes there's just no way to have a conversation without defining groups. But we have to keep in mind those groups are false. We have to keep in mind that those groups are constructs. They're not real in a meaningful sense. So when I say, who are we? Who I want us to be, who I want to be, is someone who is fighting against that very idea and is trying to demand, not only in the realm of sex offender reform, sex offender legislative reform, sex offender law reform, but generally demand that we treat people as individuals. Now, if that's who we are, if that's what we're trying to do, then I think the question of how do we lead that becomes clearer, at least. At root, leadership, I believe, is simple, right? It starts with being the change that we want to see. And that has two components. That has an internal component and it has an external component. And internally, what I believe is necessary is that we have to understand in ourselves and in others where this impetus comes from, this impetus to create an outgroup, this impetus to define ourselves in opposition to others. And I believe that that comes from, for most people, fear. You know, most of the time when people are, or if you look specifically at the history of registry laws, where do they come from? As we all know, anyone in this room probably already knows, these are high-profile, horrific crimes. Adam Walsh, Jacob Weatherling, Megan Conca, Jessica Lunsford, we all know these names. And in reaction to these crimes, there's fear. There's public fear that something has to be done. We have to get control over our lives. And it's from this fear that we get the registry laws. And I posit that in addition to this fear, generally, there's a desire to maintain social power and hierarchy. And as we all know from experience, I think, particularly in this area, once you've got a list, once you've given into this fear, that fear can be manipulated by cynical politicians. That fear can grow upon itself. The desire to control just goes on and on and on. And we see this constant ratcheting up in the laws. But at heart, what I think I want to come back to, what I encourage us to come back to, is to remember that if you push aside cynical manipulation, if you push aside greed, I believe a lot of this comes down to fear. It's the creation of a boogeyman and then a reaction to the fear that stems from that boogeyman. So if our goal is social justice reform, if our goal is to demand to push past this fear and recognize the individuality, first, I believe we have to reject this in ourselves. We have to, if we're going to demand that other people recognize our individuality, our humanity, the first step is to recognize it in others. And that goes broader. We have to reject policies based on fear. We have to be willing to give up to some degree our own power and social standing, because what's more important, what we're really fighting for, is this principle that it is wrong to lump people together, to define them based on a single act. It is wrong to deny them their fundamental humanity. And once we've got that sort of internal piece clear, once we have figured out what we're trying to do, and again, I say what we are trying to do is we are trying to get reform that recognizes the fundamental humanity expressed as the individuality of people. And once we've realized that, once we've put that into effect internally, once we've sort of identified this is what we want to do, these are the kind of people that we are as we try to do it, then we can turn that outward. As we turn that outward is where heroism comes in. Now, there's a lot of what I believe is misuse of the word heroism in the world today. A lot of people, for various reasons, want people to be heroes. But at heart, all those definitions, I think, share a common feature. That is that heroism is just the act of risking yourself for others. It's a little bit sad that I think that heroism has taken on that meaning, but it's fair because we live in a world where not enough people do that. Not enough people are really willing to risk what they have, to give up something they have for someone else. And at heart, I think it's fair to say that that's what I mean by heroism. That's what I'm saying is needed in this movement. The acts of heroism that we need in this movement are simple. But to say that they're simple doesn't mean that they're hard, but they are relatively simple. And those of you who have talked to me before know that I consistently talk about the difference between what I can do as a lawyer and the legislative movement that is really the underpinning of reform. The heroism that I need as an attorney, that I need people's help with, is I just need people to be plaintiffs. And more than be plaintiffs, I'm asking people to have the heroism to not be John Doe plaintiffs. And the reason for that is when we file a lawsuit as a John Doe, in some sense, we're giving in to the fear. In some sense, we are acknowledging that being a sex offender, and I don't know if the air quotes come across very well on the video, that being a sex offender is something that requires shame, something that requires hiding, something that is different than being an individual calling for social justice. Whereas if you put your name on the lawsuit, if you are the person willing to stand up and say, yes, I have committed this crime and I am willing to risk police harassment, I'm willing to risk social isolation, I'm willing to risk whatever the state has to throw against me to stand up and say this is wrong, I believe that is powerful in and of itself. As an attorney, it gives me the ability to put forward your story, which becomes important because as much as the law is based on abstract principles and this sort of sometimes confusing argument, it is and should be about people. And what I want to do as a lawyer is I want to work to get the courts to recognize that humanity. And it starts with a human story. All cases have a human story behind them somewhere. And your willingness as a registrant to stand up and tell your story publicly is a key not only to the legislation, but is a key to the broader social project of bringing sex offenders, again the air quotes, out of the shadows and trying to get people to recognize the individuality of every person. But again, legislation's just a piece of this. As I've said several times before, my job as an attorney is just to take bites out of the elephant. I can only nibble around the edges. I can only try to create the conditions for legislative change, because ultimately, if the legislature that enacted these laws is still the same legislature with the same thoughts and the same inputs as the one that's there after the law gets overturned, it just gets reinstituted. And we've seen this happen in North Carolina. It's just legislative whack-a-mole. We get the premises restriction shut down, it gets repassed in some other form. We get the class action is successful, the state just hems and haws, and we spend years trying to force them to do it. So I continue to maintain that what is fundamentally needed, I am not here to lead the effort. I'm here to provide and try to create the conditions for the effort, and the effort is legislative. And if you're listening to this talk, you have already signed up for the idea that you want to hear at least my thoughts on what it means to be a leader, how to do this. And I want to say again and again, and I can't emphasize this enough, to be a leader in this context is to be politically active. It is to ultimately be a lobbyist. And what I offer is, in this political activism, I believe that if we frame this not as sex offender rights, not as anti-law and order, but if we frame this as, look, you've got these laws that fail to recognize basic individuality of people. There's an in there. There's an in that cuts past some of this bipartisan divide. I've said in the past that, partisan divide. I've said in the past that when you're trying to frame a legal case, it's important to think about ways in which the arguments you're making can be appealing across the political spectrum. And in broad strokes, when we do that in a litigation context, what we're trying to do is we're trying to find ways that the specific things that we're talking about relate back to first principles, such as due process, where we say, look, we're not saying that you have to agree with our factual position, but you would agree that the process by which a factual decision is made has to be fair, right? And that's largely successful. We, as you know, attempt to frame litigation issues around issues that there is agreement in. There are things that Americans agree on all sides of the aisle: the right to free speech, the right to general freedom from governmental interference, the right to a fair process. I'm suggesting that in the litigation world, or the legislation world, we can do the same thing. And the way to do that is to emphasize that what is wrong with the registry laws is their refusal to treat people as individuals, and to point out that we would not accept this as a people in other contexts, and we as a people consistently reject this way of thinking. We want to tie the registry laws to a way of thinking, because that way of thinking is demonstrably wrong, and I think if it framed that way, you would find that most people agree with that. If you can get people to see the basic humanity underlying registrants, they will start to agree that treating registrants as this undifferentiated class of boogeyman is unsustainable. It's wrong. Now, exactly how to become politically active, how to enact that leadership, depends on your resources, depends on what you can and cannot do. But at heart, I'm encouraging everyone listening to this who wants to know how to become a leader. It's to look for ways and opportunities to have a conversation. That's how it starts. However you're politically active, whatever group that you belong to, I encourage you to start trying to explain to people why this is wrong in terms that they can understand. And if you have the resources and you're politically active, seek out candidates that will listen. Another silver lining here, there are 20,000 registrants in North Carolina, and a lot of them can't vote because they have felony convictions. But that 20,000 registrants represents 100,000 people that care about them, 100,000 people that can potentially be persuaded to see this as a real issue, that can potentially be persuaded to bring pressure. And as an article of faith, I again want to reject the idea that because we're talking about sex offenders, because we're talking about law and order, because we're talking about these topics that people find very squeamish, that there is no possibility for legislative change, that there is no sympathetic ear. I believe that it is possible that the sheer number of people that the registry now affects, combined with a reframing of the issue around this basic human dignity, this basic issue of the desire to recognize the individuality of people, can be harnessed and pressure can be brought to bear. And that's it. You know, as I was thinking about this talk, I realized I'd taken on kind of a big title, Heroism and Faith. But when I really started to think about it, the heroism here is the personal risk. The heroism here is being willing to come forward and say, yeah, I'm on the registry. This is still wrong. What have you got? I'm going to continue to say that it's wrong, and I'm going to say that it's wrong publicly. The heroism here is being willing to have uncomfortable conversations with people where you fight back against this mode of thinking, however you see it, where you're willing to point out to people who may be your friends or who may not want to hear it, that when they start engaging in this manner of thought, which lumps people together, which denies the basic individuality, they're wrong. And trying to point out to people that it's wrong on most people's own understanding. It's just inconsistent. It's not even really all that debatable. And then as we move that up the chain, trying to get into meetings with legislatures, trying to put forward legislation that maybe doesn't amount to a full repeal of the law, but at least starts to recognize that this kind of categorical legal definition and the imposition of sanctions based on categories is antithetical to everything that the Constitution and the basic American philosophy of what it means to be human stands for. And so what I would like to challenge people to do, and what I want to do in North Carolina in coordination with NCRSOL and NARSOL, is go to the legislature. And I believe that we have the ability to do this here in North Carolina and say, okay, where do we start? Where do we start with legislative reform? And I think where we start is by saying, look, you know, these laws at the very least need to be discretionary. It is wrong to apply them based on membership in a group. And say to the state, look, if you can prove to me that this person, this individual, is clearly a danger to society such that all of these restrictions are going to have every effect that you say they are, then okay, I won't fight you on that. But to the extent that you're saying this person did this, and therefore this person is this, and therefore I'm justified in saying where that person can live, where that person can work, who that person can be with, and I'm justified in doing that for the rest of their lives, I'm going to fight you on that. And I'm going to fight you on that by pointing out that you don't even believe that. You don't really believe that. Because if you really believe that, then you would have to turn that same logic onto yourselves. And so to the extent that you're listening to this call because you're asking me, you know, how do you become a leader in the fight for change? My answer, and the answer that I want to put into effect in my own life, is to think carefully about what's wrong. And what's wrong is that we're not recognizing the individuality, the basic personhood of registrants. And then go public with that. Take the opportunities that I have in my life to say that publicly, regardless of what it costs me. And that's the heroism. Heroism is simple, hard, but it's simple. And to the extent that you can, find political candidates that will listen. And quite frankly, give them money. Go to legislatures if you can and talk to them and say, look, here's the problem. Here's what needs to be done. And it needs to be done because it's right. And then see what happens. But for now, that's the answer that I've got. And I hope I hope that that's helpful. Really it. So I'll open the floor to questions, and thank you very much for listening. Robin?
Here yet. Can you hear me? Hey,
Yes.
Paul. I'm here. Thanks. Appreciate the presentation. We have a few questions and more coming in. So let me see. I've tried to go through them, and let's start from the top here. How can a registrant present himself or herself effectively to a law school and overcome the reluctance they have to admit him or her? Not exactly germane to your talk, but is that something you could handle?
Um, I think I think the answer would depend on first asking the law school, where does that reluctance come from? What is it that they're concerned about? As previous presenters have said, if it's the idea that sex offenders are dangerous as a whole, that's been debunked. In fact, there are no studies contrary to the idea that actual recidivism of sex offenders, and again, I want to keep using air quotes around that, is by and large low. It's lower than for any other category of people than murderers, by the Department of Justice's own study. So that, I would quite frankly try to go legal on them. And tied into what I'm saying is, okay, what is your concern? Isn't that concern antithetical to your educational mission, besides being factually inaccurate?
All right. Let's go to a question a little broader. How do we effectively manage fear in our society when it comes to someone on the sex offender registry?
I think the first step, as I'm saying, is try to overcome our own fear about fear. What's the saying? The thing we have to fear is fear itself. As a registrant, I encourage people to try to overcome their own fear about social backlash, about being upfront with people about who they are, not just the conviction that led to registration, but who they are more generally. I think that social fear is directly tied to this tendency to think about people in terms of groups. As I've referred to it as a boogeyman. Looking through history, there's always a boogeyman, right? Witches were the boogeyman. Jews have been the boogeyman. Communists have been the boogeyman. Satanic daycare center owners have been the boogeyman. Now the boogeyman is sex offenders. But in each of those cases, what's ultimately happened is the sheer, quite frankly, stupidity of the thinking behind those movements has caused it to collapse under its own weight. In the short term, to break through that kind of fear, you have to present an individualized face. You have to appeal to people's innate recognition of the individual. You have to get through their denial of the fact that people on the registry, like everyone else, are a motley collection of individuals that can't coherently be thought of as a uniform group.
All right, thank you. How about this one? How can we approach lawmakers and elected officials when it appears that supporting sex offenders could be a career killer?
This is exactly what I've been thinking about in the run-up to this conference, and this is what I'm suggesting. I think that there's a way, a narrow way, but I think there's a way to talk to legislatures and say, you can be as hard as you want on criminals and recognize individuality. What we're saying is not be soft on criminal. Again, I reject these kind of labels, but this is, for our purposes, the rhetoric we're talking about. I'm not asking you to be soft on criminals. I'm not asking you to support sex offenders. What I'm asking you to do is make these laws applicable only to people that deserve is the wrong word, but only to people it makes sense to apply them to. And you can appeal to positive principles. One of the things that you learn in law school is for every canon of construction, there's something that says the opposite, right? So, you can, as a legislature, you can put forward the idea, we need an independent judiciary, which means giving judges the discretion to decide whether or not someone is dangerous. Or we need to reduce spending. And so we need to only apply this to dangerous individuals. We need to, I'm a legislature for civil rights, and therefore, I'm only going to, I'm going to put a provision in the law that just says the applicability of the sex offender registry will be tied to a determination of dangerousness, not to the simple commission of the offense. And that's not a fully formed answer, but I hope I'm communicating the essence of what I'm thinking about, which is just like if you ask me, to go into a court of law and say, why are housing restrictions wrong? I wouldn't argue that they're unfair. They might be unfair, but whether or not they're fair doesn't really have a legal issue. I would argue that they, impinge upon a sort of fundamental right of choice, and that by overturning it, you're not helping sex offenders, you're helping free choice. Does that make sense? That what you're doing here is not going soft on registrants. What you're doing is allowing the judiciary to do their job. That kind of reframing, I think, is how we can start to get through this wall of, I would love to help you, but I can't because I can't appear to be soft on crime.
Okay, here's a good one for you. Somebody's asking where they can find an attorney like this, and I think they mean like you, to work with them in their own state.
A lot of people find me by looking at court cases. For anyone that doesn't know it, the website pacer.gov, P is in Paul, A, C is in Charlie, ER.gov, G-O-V. It's a website that allows anyone to look up any filing in any federal court case. And what I would recommend that people do is, in their state, go on Pacer, and Pacer has a list of all the federal courts in the United States. So if you're in Nebraska, you go on Pacer and it says, where do you want to go? And you say, I want to go to the Nebraska court. And you pull up Nebraska and then take the statute number of your registry laws, right? The registry laws have a statute number, and put that in the search engine. And what that's going to do is it's going to give you cases. And if there's a couple different statute numbers, try them sort of serially. But what that's going to do is it's going to allow you to find the cases where someone in your state has actually challenged some aspect of the registry law. And when you pull up that brief, the attorney's name and phone number is going to be on the filing in the court case. So people that have found me have done that, and I have found attorneys in other states by doing that. But that would be the most effective way to find someone who is actively litigating these issues in your area. Some states have a similar system, North Carolina doesn't, but pacer.gov is the federal link, and that's where I would go to start your research.
Okay. Next question. Perhaps this is a bit commentary here, perhaps those on the registry's biggest fear is to go to jail for a compliance violation. It's difficult to say there's damage or could be damage when no arrest or damage has actually occurred. So is it a part of civil rights and perhaps an obligation or an interest on the part of sex offenders, registered sex offenders, to be brave enough to risk arrest?
Yes.
That's your answer?
Yes.
Go to the next.
There's a lot of ways to get mealy-mouthed about that, but yeah, I mean, being willing to be arrested, being willing to, take the consequences, to stand up and say something's wrong, is an act of heroism. This is analogous, but not nearly at the same level of seriousness. But I had a cousin a few years ago who was furious that his landlord had kicked him out of his apartment after finding marijuana, during a routine light bulb changeover or something. And what I said to my cousin is, look, you're lucky the landlord didn't have you arrested. And I don't sympathize. You broke the law. You got kicked out of your apartment. It's your own damn fault. But the other thing I said to him is, if you want to go to the courthouse and light up a joint on the steps of the courthouse because you believe that this law is wrong, I'm all behind it. I'll defend that all day. What I don't like is the idea that you would get mad that you can't break the law with impunity. But if you're breaking the law knowing you're breaking the law, or if you're willing to risk arrest to make a point that you think is important, I have nothing but respect for that. And I have nothing but respect for the registrant who chooses to put themselves at risk to draw attention to the situation.
Okay, thank you. Next question. The United States Supreme Court, parenthetically in Packingham versus North Carolina, expressed dismay that registrants are subjected to onerous prohibitions and affirmative requirements based solely on the offense of conviction, rather than on an individualized assessment of their dangerousness. Are there any pending cases that seem queued up to place that issue before the High Court? That's probably
not that I'm aware of.
yeah.
If I had to guess, that will come up first in the context of ex post facto litigation. But this is one of the areas where the limitations on what it is and is not constitutional sort of runs into the disjunction between what we understand to be core principles and the way these laws play out. And by that I mean that issue isn't really a clear legal one, right? It's a little bit difficult outside sort of the vague notion of substantive due process to envision a case where the legal issue is it constitutional to base these restrictions on the offense of conviction? That has to come up within the context of some specified constitutional provision. So I think, and I hope, that we'll continue to see cases that allude to that, but I'm unaware of, and I would be a little surprised, though I've certainly been wrong about this kind of thing before, to see that issue squarely before the court. But the comment is really good because I think that is the point of discomfort. And I think that's the point that needs to be poked on. It's the idea that we're legislating based on groups, that we're saying because you did this, you are this. That's fundamentally what's making people uncomfortable because it's fundamentally at odds with our basic understanding of what it is to be a human being. And so the court's expression of discomfort, I hope, is an expression of discomfort shared by a lot of people, and frankly, an expression of discomfort that we can work with to encourage legislative reform that stops it.
All right. This is more directed, I think, at you personally. I have a question here. Somebody's asking, what are you doing to help recruit and train freshly minted attorneys across the country to help in our reform efforts?
I, in the past 4 months, have taken to 3 cases in which an attorney contacted me and said they have a client that has a registry issue and asked me if I would help. And the answer is absolutely, if I'm at all able. I also have spoken to 2 attorneys in the past 3 months that have asked me, okay, how do I get into this? And I've said, okay, here's what you need to do. But basically, what we have as attorneys is no lack of work, unfortunately. So any attorney that is interested in doing this work is more than free to contact me, and I will give them all the resources that I have. And frankly, I've even got some cases on the shelf that I could use their help with. So please call me would be the answer.
All right, great. The next question is from one of your colleagues in the profession. Another attorney is asking, do you believe in incrementalism? And is that something that we can use to overturn sex offender laws?
I don't, if I understand the question right, incrementalism would be the idea that you take small victories and you sort of, you try to slay the elephant, or eat the elephant one bite at a time. And I don't know that incrementalism is something you believe in or not. I will say that, do I believe that small victories lead to larger victories? Yes. Do I believe that the history of civil rights litigation in this country supports the idea that you sort of take the most egregious violations and you try to build up a track record? Yes. I'm always mindful of Teddy Kennedy saying that his biggest regret was not allowing a very small public health insurance law to take effect in the 70s in hopes of getting something bigger, because he believes that if he had allowed the small law, it would have just grown. And by now he would have been where he wants to do. So I'm not against the big swings, but yes, I believe that we should take victories where we get them. And I believe that the sum total of small victories is large victory. And if that's believing in incrementalism, then yes, I do.
Okay, thank you. Somebody here is asking whether or not you could provide any insight on the legality of personal safety means. I think that perhaps measures is a better word, for registered people to protect themselves and to protect their family and their property uh, out of fear of vigilante justice. Any insight on that?
That's going to be a question of state law.
Yeah, it really depends on where you're at. It's more of a legislative question, I guess. So, do you see any value in registrants burning their registration cards, similar to burning draft cards during the Vietnam War? You may not want to answer that one. How about this one? What do you think is the best way to determine?
No, I don't want to not answer the question. I just want to give a thoughtful response.
To ponder it. Yes.
I see a lot of value in registrants empowering themselves. I see a lot of value in registrants being willing to stand up publicly to say, I am a registrant and this is wrong, and it's wrong for these reasons. I see a lot of value in registrants working to overcome their own fear and become public advocates for change. Whether burning a registration card is effective that way, I don't know. But again, I respect people who are doing their protest publicly. I respect people who are not saying behind closed doors, we need this for change, not, saying only when it doesn't matter that they want this. I can't tell you whether or not to burn a registration card. I can't tell you whether or not that's effective. I can tell you that I respect the impulse behind it. And I encourage registrants to look for ways to publicly say, I am a registrant and this is wrong. And to the extent that I am able as an attorney, I'll protect their right to do so.
Okay. Got a question here on international Megan's Law. I know you love those questions. Do you have any insight about what it might take, or is it possible to get rid of international Megan's Law?
I've said before that I'm certainly not the final arbiter of what will and will not be successful as a lawsuit, but this is a good example of a situation where I don't see a clear lawsuit that would just do away with Megan's laws, with international Megan's law. So, is it possible to get rid of international Megan's law? As an article of faith, I say yes. Is it possible to do that right now? I don't think so. Is it possible to do it as part of sweeping reform? I hope so. Going back to the earlier question, do I believe in incrementalism? I do think that something like Megan's law being repealed would be something that happens after a series of smaller victories. But I don't think that means it can't be done.
Okay, next question. How can a process in one state be declared unconstitutional in that state and not be unconstitutional in all states? And why do we have to keep reinventing the wheel in each and every state? Can you speak to
Could
that?
you repeat that question?
How is it that you could have a statute struck down in one state declared unconstitutional, and that doesn't necessarily apply to any other state? It's more of a question of jurisdiction, I think, but
Right.
it's
So,
probably useful to get a response from you because it's edifying.
well, the technical answer is because the Eastern District of North Carolina has no power to say what is and is not constitutional outside the Eastern District of North Carolina. Just like right now there is a direct split between the 10th Circuit, which would say that a due process violation is subject to a statute of limitations, and the 4th Circuit, which would say that it's not. Ultimately, only the Supreme Court has the authority to declare the meaning of the Constitution for the whole country. So, unfortunately, that means that, yes, largely, unless and until the Supreme Court rules on an issue, we have to go state by state. That's not a satisfying answer, but it is the case that a court can only make the law for its jurisdiction. And other than the Supreme Court, every court is a court of limited jurisdiction.
Okay. Thank you for that answer. Is there a chance, in your opinion, that social media, such as Facebook, Match.com, will ever stop denying registrants the opportunity to have accounts?
I hope so.
Here's another one for you. You were described as brilliant, and you're being asked if you'd ever thought of speaking on PBS to expose this issue to a wider audience. I guess it would depend on getting invited to do that, wouldn't it?
I hope that what I'm saying to everyone listening right now, that I will apply it to myself. And, to the extent that I'm ever given an opportunity to talk about these issues and to express my personal belief that they're wrong and the reasons why, I would be happy to. I think all of us who want to be leaders, who want to be advocates for change, who want to live in a world where we overcome the fear, the manipulation, all of the factors that lead to these kind of laws, are also willing to take whatever platform we have, even if it means making people uncomfortable, even if it means some harm to ourselves in some way, of speaking what we understand to be the truth. And I hope that if given that opportunity, I'll live up myself to what I'm asking you all to do.
One of your fans from your plenary session in Houston was very impressed by what you had to say on due process. Is asking if you could explain a little bit more about why you like this approach to litigation, this due process approach.
Because due process is a shining example of what I'm talking about, of getting back to first principles. Due process is not a partisan issue. Due process doesn't depend on whether someone's guilty or not. It doesn't depend on your view of what appropriate punishment or not. Due process is where we say that it's the sort of fundamental right of an individual. It's where the rubber meets the road, where our law says, no, if you want to deny someone some aspect of their liberty, some aspect of their humanity, you have to prove it. And if you're not proving it, you can't do it. And for that reason, I like it as a litigator because it's so important and because it's under attack in our country right now. I like it in terms of litigation because it cuts through partisan lines, right? It allows me to appeal and advocate for our fundamental understandings of what the rule of law is. And I like it because it gives me an opportunity in a very clear way to practice what I preach and fight against this sort of wholesale denial of individual and humanity that we see in the registry laws and elsewhere in our country.
All right. Well, that is just about it for time, Paul. We certainly appreciate you being here today. I know some of these questions were a little bit tough, and you probably didn't expect them, but I didn't expect to be asking them either. So thank you. We appreciate you. Appreciate your service to our advocacy. We certainly appreciate you as our general counsel at NARSOL, and speaking on behalf of North Carolina RSOL, we also appreciate your counsel there as well. So thank you for being here today.
Thank you all. Take care.